Good morning, everyone, and welcome to MacDonald and Associates monthly webinar that we offer to inform you of all of what we can do in a half an hour as to the recent and pertinent issues that we see in employment law today. And of course, on the tip of everybody's tongue is in fact the recently passed Bill 148 and the amendments thereto. This has been something that has been a long time coming in the province of Ontario. I am here today with my associate Jeff Lowe, and Jeff can provide us, I think, with a better history because he's really dug into the manner in which this has transpired.
Yes, thank you, Natalie. Hello, everybody. So Bill 148 is the culmination of about a 2-year process by the Government of Ontario. Beginning in 2015, the government and the Ministry of Labour identified the need for a review of precarious employment in Ontario. This was personified, and this was created by something called the Changing Workplaces Review, which was staffed by a former retired justice, Chief Justice of Ontario, and a retired lawyer. These individuals identified a number of things in areas they needed to review regarding the law and review regarding employment law. This consisted of seminars across the province and a number of meetings and fact-finding missions. This began in 2015 and persisted into 2016 and into 2017. 2016, the Changing Workplaces Review issued its interim report, which consisted of having identified 50 areas that it intended to write on in its final report, and an additional 200 areas it intended to consider reporting on. The review ultimately was published in May of 2017. It contained suggestions for changes to the Employment Standards Act, the Labor Relations Act, the Occupational Health and Safety Act, and several other additional acts attached to this. It contained approximately 400 recommendations, none of which involved the minimum wage, none of which involved the stuff we're looking at now. It's primarily focused on enforcement. Subsequent to this, Bill 148 was introduced about a week and a half later, which is this beautiful thing right here, Bill 148. This first reading was in June of 2017. There was a reading, an initial reading by the Ontario Legislature, and then there were a series of consultations across the province over the course of about, I think it was about 2 months. They went around the entire province and did about 10 meetings, all of which are available on the Government of Ontario's website if you want to review the question and answer. This resulted in a number of suggested changes, which were put into the bill after it went into committee and came back out in October of 2017. Its third reading was on November, and the final reading, and that was the final reading, which is the bill we see before us today.
And so on November 22nd then, right, Jeff, yes, the Ontario Legislature finally passed Bill 148, which, as we all know, becomes law on January 1st, 2018, although certain parts of the bill are only to be implemented by January 1st, 2019. And while the intent of Bill 148 is very admirable and very laudable, particularly in today's environment of changing workplaces and the way in which work is done, the practicalities of its enforcement, in my view, continue to confound employers all across the province. In particular, small business has really reacted, given that it really is going to significantly impact on the manner in which small business conducts itself. Additionally, it will have quite an impact on those businesses who rely on temporary workers, shift workers, and contract workers, because it's really going to demand that employers take a look at their scheduling and make sure that their scheduling is consistent with what the bill requires. Now, in respect of that, changes in in regard to leave of absence provisions, which are already contained within the actual Employment Standards Act. And of course, as we know, Bill 148 becomes the amendments to the Employment Standards Act. That's really what the gist of it is. But in respect of that, the provisions for, you know, leave of absence for pregnancy leave and parental leave and family leave and all the, all the other leaves will be extended, and those are really just set out in the Act. But one of the new provisions contained within the Bill 148 legislation, which is incredibly important, is the idea of domestic and sexual violence leave provisions. And I think in the wake of Harvey Weinstein and, quite frankly, all the other shoes in Hollywood that have dropped, as well as the constant, I think, idea that we are seeing regularly now of sexual harassment in the workplace, and more people coming out with their own stories of what has happened. These leave provisions are very admirable and certainly something that every workplace must adhere to. And what happens with respect to those leave provisions is that any employee dealing with domestic abuse issues or sexual violence issues has the right to have up to 15 weeks of leave, but the employer is only required to pay for 5 days of that leave. Well, certainly it is admirable that we have this section in the Act. Obviously, employers are now going to have to start to pay for that leave for the employee and pay up to 5 days of it. Of course, employers will be able to ask for some documentation to verify the employee's leave and what is reasonable under the circumstances, but that's a very significant change in Bill 148 right now. Additionally, we have new provisions pertaining to personal emergency leave. And Jeff, perhaps you can give us some information in respect of that.
Absolutely. The personal emergency leave, as it currently exists in the Employment Standards Act, has a threshold requiring employers to have at least 50 or more employees actively employed at their firm before they are required to offer this leave. Additionally, the leave consists of 10 unpaid days to attend to personal emergencies such as personal illness, death or illness of a family member, or an urgent matter concerning an individual related to the employee, generally a family member. The changes in Bill 148 substantially expand the accessibility of this leave. They've removed the 50 employee threshold. The same criteria apply in terms of which employees are entitled to access this. The length is the same, but now employers are required to provide the first 2 days the employee takes off under this leave as paid days. So effectively, this provides employees with 2 paid sick days, which did not exist in the Act previously, and it's a dramatic advancement.
Now, we've had a few questions that have come in, as a matter of fact. Jim, I believe you asked a question about paid sick day entitlements and how that works. Your question specifically is, how does the paid sick day entitlement start for all employees? And the answer to that, first of all, is it comes in 1 week after they have been employed with your organization. And the employee is entitled to 2 days paid leave in each calendar year. I understand from your question, you also have many employees who leave and then return. Does this mean that their paid sick day balances start anew on their return to work? No, it does not, as a matter of fact. It means that the employee is only entitled to 2 days in a calendar year. However, I'd like to point out that certainly with respect to your organization's contracts and the policies, if there is a greater right or benefit that your organization is offering, then of course that would be presumed to be the one that would be the benefit to which the employee would be entitled. So you're going to have to definitely take a look at your contracts and your policies to ensure that they are, first of all, to ensure that they are compliant with this, but if they offer a greater right, then that's the right you have to offer to your employees. I had a question in respect of switching people to salary rather than hourly due to the minimum wage legislation. And you asked whether there was an issue with having to pay overtime if the person works more than 44 hours. Anyone who works more than 44 hours who is not classified as a manager is entitled to overtime. But you need to put provisions in place that make it clear that the person has to have permission from you to be able to claim the overtime, and that it has to be in writing. That's something we encourage all our employers to do to ensure that overtime is correctly handled. We also encourage averaging agreements, and that's a way in which you can pay overtime through averaging it. Jeff, do you want to tell us a little bit more about that?
Absolutely. Thank you. Averaging agreements are a provision in the Employment Standards Act. This requires that the employer, or permits the employer, I'll give you the idea of it first. This permits the employer to average the amount of overtime an employee works over the span of 2 weeks, as opposed to paying it on the basis of an individual week. So as you've asked in your question here, Jim, do we have to pay overtime if the person works more than 44 hours? Yes, obviously, if an employee works more than 44 hours in a week without an averaging agreement, you do. An averaging agreement permits you to average the amount of hours the employee works over the course of 2 weeks, and then determine whether or not the employee is entitled to overtime. So it's if the employee has worked more than 88 hours in the 2 weeks, effectively. You can't impose this unilaterally. This has to be at the consent of the employees, exactly. And it has to be remained on file, and it has to be filed with the Employment Standards Branch of the Ministry of Labor.
So in order to get that consent, we strongly recommend that it be in writing. As we do everything. Everything should be in writing, but this in particular, because otherwise it won't be enforceable. Now, of course, you brought up the issue, Jim, of obviously minimum wage. We all know, because I think that's one of the most publicized parts of Bill 148, that obviously minimum wage is increasing from $11.60 to $14 by January 1st, 2018. The second phase bumps it up to $15 January 1st, 2019. That is also subject to annual inflation adjustments, and that's going to take place on October 1st of each year, beginning in October of 2019. So while you're updating your policies, you want to ensure that that reflects an annual inflation adjustment as well. Very good language for any policy is to ensure that your policy complies and the employee will receive no less than what the employee is entitled to pursuant to Employment Standards Act entitlements. So thank you, Jim. We hope that answers that question. We have another question in relation to stat pay calculation. And in particular, that comes from Shirley. Shirley, you wanted to know that your first payroll in January is going to include January 1st, and this part comes into effect on January 1st. You're quite right, but you're still going to have to pay for the stat pay calculation, and it will be paid as follows.
So this is addressed in subsection 24 sub 1 of the Employment Standards Act, beginning in January of 2018, when Bill 148 becomes law. So previously, it would be based on an averaging of the employee's salary over the span of 4 weeks prior to the statutory holiday. Currently, and the change will be the amount of regular wages earned in the pay period immediately preceding the public holiday divided by the number of days the employee worked in that period. So you effectively take the employee's final paycheck previous to the statutory holiday, divided by the number of days they worked, and that's the amount of money the employee's paid on for that statutory holiday. The alternative is if the employee was not employed prior to the public holiday. This is section sub 1.2 of 16. Section 24 is that if the employee was not employed prior to the pay period, in the pay period prior to that public holiday, their pay for that statutory holiday is based on their pay period subsequent to it. So it's the same calculation, only it's for the time they worked after the public holiday and not before it.
So definitely you have to pay them per the Act on January 1st, 2018. Hope that answers your question. Sandra, we have a question from you regarding personal emergency leave and contracts. Sandra, you state that you currently offer all staff after the successful completion of probation 3 sick days, 4 personal days, and 10 vacation days, and you've offered 10 unpaid days per year, even though you are obviously under 50 employees, so fantastic, very good policies to adapt. Do you now have to provide, you've asked, first of all, how does the 2 paid days out of 10 affect policy and procedures? So first of all, if you're already offering it, then you're already compliant, and good for you, because you don't have to do anything else. And you've asked, do we now have to provide six days unpaid as you had already provided 4 paid personal days, or is it still 8? I think 6 days is sufficient, and specifically, as long as you're in compliant with the Act, which you are, you shouldn't have any issues. Again, I go back to the point that I've made earlier. As we all know, Employment Standards Act entitlements are merely the basic bare minimums that employees are entitled to. If your organization is in fact providing a greater benefit or right, then you will always be looked at to provide that greater benefit or right. So I think certainly from what you've said, you're compliant and your company is as well. We had another question. As a matter of fact, this had to do with a collective agreement, and Rebecca, I believe it's a question from you. Spelling out, you've asked if the collective agreement spells out different levels of pay based on hours of work or years of service. Do you abide by the collective agreement until it expires, or does the new legislation come first and all employees will have to get paid the same wage for the same role? And that's a great question. First, I think we can tell you that you do fall into likely the exceptions that are outlined in the actual Act in respect of the difference in employment status. And that is in respect of seniority, which years of service, and your hours of work. But you've asked, so I think you'll fall into that category from what you've said, but you've asked, do you abide by the collective agreement until it expires, or does the new legislation come first? The collective agreement, if it has something different to what Bill 148 has, it's going to hold in place until it expires or until January 1st, 2020. However, I'm sure your collective agreement likely has a clause within it that specifically outlines that you are compliant with the Employment Standards Act and you will abide by the Employment Standards Act to ensure employees receive no less than. But in respect of the collective agreement, there's a particular provision that allows you to either have it expire or January 1st, 2020. Is that correct?
That's what I understand it to be, yes, absolutely.
Okay. We had another question. Jeff, maybe you want to take that question, read it out, and provide it to Phil.
If you currently offer it, they are for only. You have to honor the 8+2 paid personal days, since what you're offering is better. Of those sick days to align with the ESA explanation. Thanks. That's a great question, Phyllis. You are offering, as Natalie's mentioned, you are offering a greater right or benefit here, which is fantastic. My only concern with this is that because you're indicating that they're for the employee's sick time only, you may have a situation where you're not in exact compliance with the Employment Standards Act. I think the optimal thing for you to do here would be to take the definition of when an employee is entitled to take leave for that's spelled out in the personal emergency leave, specifically in subsection 1 of the personal emergency leave. An employee is entitled to take a leave of absence because of any of the following, and you'll notice it lists off 3 things. If you change the wording in your leave to indicate that, then you're offering a greater right or benefit. You don't have to offer a parallel personal emergency leave.
So hopefully, Phyllis, that answers your question. And we'd like to move on to the question actually from Evangeline. And Evangeline's asked a question which I think actually is one of the most important issues that we're going to be addressing and that we see our employer clients address. And that is the misclassification of workers. And I got to tell you folks, before I start answering a question on this, this is an issue not just for employment standards legislation, it is for the common law. And the reason it's become an issue is because the nature of work has changed so much. The way we work, the flexibility of the workplace, the manner in which work is actually conducted has changed dramatically over the last 10 to 20 years. And so we're seeing very different strands of what was, used to be the employee always showing up in the office, working for the employer 9 to 5 and then leaving. In fact, I don't think the concept even exists anymore that there's a 9 to 5 workplace. We're constantly inundated by demands from, our email to text to cell phone messages, you name it. But Evangeline's asking the question, if a worker is treated as an independent contractor for 10 years, 10 plus, but when reviewing the test to identify the classification, the worker is classified as an employee, what are the risks for the company and the contractor? So an excellent question. Here's what's going on. Years ago, there used to be the concept of the independent contractor. And the whole concept of the independent contractor is that the contractor is free to contract with whomever or whatever businesses other than your business that the contractor wants to. And if you've done it correctly, you'll have a very well-written, well-drafted contract in place that states and stipulates that the contractor is not an employee, that in fact they remit HST, that you don't have anything to do with that, and they don't share in any of the perks, nor are they controlled by the organization in any way. That was the true independent contractor relationship. Over the years, this has become a very muddied concept, and it has because of the fact that employers exert more and more control over independent contractors. Organizations will do that. In addition, there has been a recent concept that has arisen from court cases where a court has found that if the worker is economically dependent upon the organization for all its work, then really they are more likely to be an employee than they are to be an independent contractor. And thus the notion of a dependent contractor has arisen. And the notion of dependent contractor is built around economic reliance on the organization in question. So if that worker is able to prove that in fact everything they have done and all the money they have received has come from your organization, it's likely that that worker is going to be found to be a dependent contractor. Now, what this means is that the courts will treat a dependent contractor like an employee and handle things in the same way in which an employee would receive their entitlements. So for example, employees are entitled to reasonable notice upon the termination of their employment, or severance pay as it's often referred to. In this case, if you were found to be a dependent contractor, then the actual organization would be responsible for providing the dependent contractor with the same amount of reasonable notice that it would give to an employee. And I can tell you with respect to Bill 148 in particular, there's a provision in there that if a worker suggests that the worker is in fact an employee, then it's incumbent upon the employer or the organization to prove otherwise. So a worker doesn't have to go in and prove that they're an employee, prove it. And boy, you've got to be ready for that. You've got to have your contracts in place. You've got to have your policies in place. If the work relationship is truly independent, it should be reflected in the contract, and it should be specifically, I think, made clear that there is no control that is exerted over that independent contractor. Otherwise, you run a huge risk of the the worker being deemed to be an employee and therefore subject to the same common law entitlements and same entitlements pursuant to the Employment Standards Act. Now, in terms of the risk for the company, if the company has always treated this person as an independent contractor and the court or the Ministry of Labor finds that not to be the case, CRA can become involved, and they can take a look at all of the taxes that the organization has not paid and assess the taxes and say to the organization, you're now responsible for paying 10 years of back taxes, whatever that amounts to. So it's a really risky proposition, but if it's well papered and it's well constructed, hopefully you should be okay with that. But if it's not, it's time to definitely reassess, take a look at that contract, take a look at the control factors, and determine whether or not your worker is going to be found to be an independent contractor or at least a dependent contractor. Jeff, would you add anything to that?
I'm not sure I could. That's ideal, especially the CRA stuff. That's perfect.
Okay. So, I mean, that's something that you really want to ensure you get a hold of, folks. And so now's the time. I mean, we always, around this time of year anyways, recommend to our employer clients that they start looking at their policies, taking it off the shelf, so to speak, and revising and ensuring that it is compliant with the legislation and the manner in which the case law has changed. Now is your ideal time to do that. Obviously, you need to do that in terms of being compliant for January 1st, 2018. What we haven't talked about is the scheduling provisions. Now, they only come into effect January 1st of 2019, but I can tell you that that is one of the largest issues that's confounding the workplace. And the reason that it has is because it's become even more important now that there's an employee's right to refuse work if in fact the employee is not scheduled to work and the employer calls the employee to work. They actually have to give that employee 4 days notice, 96 hours, I believe it is. And then if the employee is scheduled to work, to be working the schedule, if the employer does not want that employee to work, then the employer has to give the employee 2 days notice, at least 2 days. And that's going to present a problem to us because, of course, you've got the idea of on-call. Maybe your clients don't call in until the day before. Maybe you can't assess things. So you're really going to have to think about how you reschedule your workplace. And you've got a year within which to do that. So that's great. But you need to start thinking about it now. So of course, is that if an employee is on call, then if the employee essentially works for, I guess in the on-call, if an employee who regularly works more than 3 hours a day is required to present for work but works less than 3 hours, pay that employee for those 3 hours. And the same if that employee is on call. The exception on the on-call, aside from force majeure clauses, which are contained in the Act, and I'm still a little unsure of how that came to be, but anyways, the issue is that if the employee has not worked at all, but they're on call, you don't have to pay them. So that's one thing that you could look at to, escape that provision. But otherwise, you're going to be stuck with 3 hours of pay. And so if you don't properly schedule your employees, it's going to be a problem. So we strongly recommend that you review your schedules, you review your contracts, you review your policies, and you review specifically what kinds of terms and conditions you want to see in place in your workplace, and have the workplace work for you, not have the Minister of Labor or the civil courts what they want to do to you. Having said that, I believe we're at the end of our webinar today. We hope this has been of great assistance to you in navigating this treacherous ground, and certainly happy to always be of assistance. We look forward to seeing you, I guess it'll be next year, and wish you all a very happy holiday and all the best in 2018. But make sure you're compliant with Bill 148. Thank you, everyone.
Thank you, everyone.